So we'll be talking about the scope of the Alien Tort Statute, Article 3 jurisdiction, Article 3 standing to challenge surveillance, and federal habeas. So we have a terrific panel with us. To my left is Tom Goldstein of Goldstein and Russell, and also the founder of SCOTUS blog, the best source of information for the United States Supreme Court, particularly as compared to CNN and Fox. To my right is Neal Katyal, currently at Hogan and Lovells, former acting Solicitor General and also Georgetown law professor for many years, who's written extensively on the subjects we're talking about today. And finally, to my far right, we are very, very privileged to have here with us Judge Diane Wood of the U.S. Court of Appeals for the Seventh Circuit, based in Chicago, Illinois. So we are going to start with Neal, and he's going to talk about Katyal versus Dutch Petroleum Company, which is on page 141 of your materials. And Neal, you can tell us what's going to be left of the Alien Tort Statute.
Okay, well, thank you. It's a real privilege to be at the conference and particularly to be on this panel with such distinguished folks. So you have a 1790 statute, and the statute extends jurisdiction to federal courts, quote, over any civil action by an alien only committed in violation of the law of nations or a treaty of the United States. That's the statute. Now, if you knew what it meant, then you're ahead of the game, because nobody knows what it has meant for almost 200 years. This statute was lying around. Nobody was doing anything with it. And in 1980, the Second Circuit, in the case called Filartiga, breathes some life into the statute and says, you know, you can use this to sue for human rights violations. And that led to hundreds of lawsuits, first against people who were alleged torturers and the like, but ultimately the plaintiffs' bar realized there's another set of entities that can be sued under it, and that's multinational corporations. And now, at this point, most of our, a great chunk of our Fortune 500 companies have been sued under the Alien Tort Statute on the theory that they were propping up some sort of human rights violation abroad. In this case, in the Katyal case, 12 Nigerian nationals sued Shell, Royal Dutch Shell, which is a company based in the Netherlands and in the UK, and they alleged that Shell had propped up the military junta regime between 1992 and 1995, and they sued Shell in an American court. The Second Circuit, in an opinion by Judge Cabrera, said, you know, you can't sue corporations under the Alien Tort Statute. You might be able to sue individuals, but going further than that to corporations, they said you couldn't do, that there isn't a tradition of corporations themselves violating international law. International law generally binds state actors, they said, not private corporations. And then the Supreme Court granted certiorari on this, and indeed I imagine last year, I wasn't here last year, but I assume that there was some other panel in which people were talking about Katyal versus Royal Dutch Shell and the question of corporate liability, because cert had been granted on that question, and indeed there was an oral argument on that question last year as well. Now, there are a bunch of people in the Supreme Court bar who think oral argument doesn't matter. I think it's a pretty good example of where oral argument does matter. At the argument, one of the very first questions posed to the plaintiff's lawyer, Paul Hoffman, was by Justice Alito, who, in my mind, is rapidly distinguishing himself as being just, questioned in terms of per capita. He asks very few questions, but boy, they're good. And this one, he said, let me just repeat to you the first line of your cert petition. The first line of your cert petition is 12 Nigerian nationals sued, approximately 12 Nigerian nationals sued Royal Dutch Shell Corporation for a violation of human rights abuses that took place in Nigeria between 1992 and 1995. He said, what in the world is that doing in the United States Federal District Court, that case? And Mr. Hoffman really kind of stumbled around for an answer and didn't have one right then and there. And I think that's what led the court, a week after the oral argument, to grant a rehearing and re-argument on the question of whether or not the Alien Tort Statute applies extraterritorially. And so now that's the new question before the court. It'll be argued just in a couple of days on Monday, the first argument of the term. So the question is, does this statute that I just read to you cover conduct that takes place abroad? And Royal Dutch Shell, as you might expect, says no, it does not. And they point out that a couple of years ago, the Supreme Court in a case called Morrison said that there was a strong presumption against extraterritoriality of statutes, that when Congress wants to extend a statute to apply beyond the United States, they have to say so clearly. And that case had to do with securities laws, and they say here, same thing. The statute doesn't say you should, that it applies abroad. They got to say so in order for that to happen. Now, the response by the plaintiffs is, well, that presumption doesn't apply here for a couple of reasons. One is the Supreme Court, I guess in 2004, in their only decision on the Alien Tort Statute, in a case called Sosa, said that there were kind of three paradigmatic examples of where the Alien Tort Statute applied, and one of them was piracy. And so the plaintiffs say, look, if piracy is covered, and it's the heartland of the Alien Tort Statute, well, that's not something that's a crime. You don't have like Captain Blackbeard on the Mississippi River. That's stuff that's happening outside of the United States. And so therefore, if the statute envisions that, that's kind of a good clue that Congress anticipated that would apply extraterritorially. They also say, picking up on something that the DC Circuit has said, that the statute applies extraterritorially because the presumption against extraterritoriality only extends to it only extends to substantive statutes, and the Alien Tort Statute is merely jurisdictional, and so it doesn't raise some of the same concerns that extraterritorial statutes have in general. The last thing I'd say about this case is that the United States government has come in and filed a very compromised brief. This is a brief that says, well, the Alien Tort Statute doesn't always apply extraterritorially, but sometimes it might. In this case, it doesn't, and it lays out a whole series of factors that a court is to look at in determining whether or not the statute applies extraterritorially. This strikes me as a tough position. It's a position that's inconsistent with what the government has filed before, just a few years ago. And the case law has gone all in the direction of extraterritoriality being presumptively wrong. So it's in tension with where the court has been going. And it's an odd result. I mean, the result of this brief is to say that U.S. corporations will be liable under the Alien Tort Statute, but foreign corporations would not, which strikes me as a very perverse rule. It's a rule that says if you're a U.S. company, you're especially disadvantaged, and a rule that will undoubtedly, if adopted, encourage U.S. companies to just set up shop abroad and to avoid these multi-billion-dollar potential liabilities. So that strikes me a hard position to win. A hard position in general for the plaintiffs in this case, it seems. The court's direction is really against extraterritoriality. There was a fair amount of hostility to the statute and oral argument the first time around.
Tom, Judge Wood, questions?
Well, I just wanted to add that, in a sense, the broader issue from the point of view of international jurisdictional theory is the extent to which this particular statute is seen as reflecting what's sometimes called universal jurisdiction. That is the idea that if it's something like piracy, or if it's something like genocide, or if it's something that's so heinous that any country in the world has the authority to punish it at all times. This is a theory that, as you probably know, Israel has invoked on a number of times for people accused of Holocaust offenses, and it's a theory that floats around in the background of this. And I think that the idea has been that there are some things, whatever your list wants to be, that are just, in a sense, crimes, or torts in this instance, against humanity. And the Supreme Court has not signaled any great affection for this theory, but it is a broad one, and the case will be watched for how it handles that.
I think the case is very interesting for a point that Neal touched on, and that is the position of the government in the case. In the first go-round of Katyal on the question of whether corporations could be held liable, the State Department fully participated in the government's brief and signed it, and it doesn't the second go-around. And I think that the compromise that's articulated in the government's brief really reflects disagreements within the federal government about the scope of the statute. So the United States says that this very first case, Ortega, that the Second Circuit had, where the defendant was living in the United States, even though the offenses, alleged offenses and violations of human rights occurred abroad, that is a case where you could have jurisdiction in the United States. And the government, I think, is just caught betwixt and between the State Department's desire to have, in the Obama administration and Harold Coe, the desire to have some greater force in the statute.
Do we have questions from the audience on Kiobel? I have a question. Oh, here we go. Thank you.
Yeah. It seems to me that the piracy argument doesn't make sense because you don't have jurisdiction on the high seas. And so it seems to me to try to carve out an exception based upon the privacy would be to disregard the understanding that jurisdiction is basically land-based, not based on the high sea.
But that is the whole point I was making about universal jurisdiction. All countries assume the power to punish pirates because they are beyond the borders of any particular place. And we have a few places like that: the high seas, Antarctica, the surface of the moon. You know, seriously, there's a treaty about that. And this idea of universal authority to punish something like piracy is very long established.
And there is this interesting tension between universal jurisdiction in the sense that there are crimes like torture and stuff that all nations recognize as evils. But there's a separate question about the forum in which those things should be vindicated. We all agree that there are these evils. Does that necessarily mean that there should be a civil lawsuit in a federal court to deal with that problem? That's not necessarily something all nations of the world agree upon.
And I should add, too, I mean, as Tom points out, when you have the person in the United States, maybe that's a little bit different, but there's an interesting question about how much work you want this statute to do, because needless to say, just because you might have decided that the Alien Tort Statute establishes subject matter jurisdiction in the court, and you have now found some tort that creates a cause of action, you still have personal jurisdiction restrictions. You still have the doctrine of forum nonconvenience. There are all kinds of tools available to the court to say this lawsuit doesn't belong here, and whether you want the 1350 statute to carry all the weight or whether you're willing to spread it out a little bit is an interesting question.
Yes.
I'm curious the panel's take on the second argument here of the case by petitioners. How much, if any, of the argument that they have to make now to try to make the ATS hold the water that they needed to hold actually undercuts the merits argument that they wanted to make last term? And whether trying to, Mr. Katyal, you mentioned that the presumption against extraterritoriality, that the petitioners were trying to get around that by saying that the ATS is jurisdictional, but that isn't there a danger of pinning too much on the jurisdiction argument of the Alien Tort Statute that's actually going to undercut the corporate liability argument that they were trying to make last term?
It's an interesting point. I think perhaps not. I think what they would say is the Alien Tort Statute creates jurisdiction. The substantive question of whether corporations are liable is a question about whether or not that phrase law of nations corporations can violate or not. And that the statute merely is just recognizing a cause of action that exists elsewhere in law, in the sense of the law of nations. So I don't think their intention. Your question's a good one, though, because in play still is the corporate liability question. And so Shell essentially has two ways to win, and presumably they'd be happy with either of them, whereas the plaintiffs have to win both pieces of the puzzle in order to advance the ball.
We'll take one more question on Kiobel.
Is there some tension somewhere in the background with our going off in criminal context, shooting some people and then seizing others off the coast of Somalia, bringing back the United States, prosecuting them under 1790 statute, with the U.S. government asserting like mad that, of course, there's no problem with jurisdiction for people that we captured in the act of piracy off Somalia. One would have thought that civil liability is kind of a lesser remedy, and is the U.S. government being entirely coherent here.
That case is pending now before the Fourth Circuit. I haven't read those papers, so I don't know, but that does proceed under a different statute that I think is more specific than the one that the one I just read to you about, the Owing Tort statute.
All right, so we're gonna move to Clapper versus Amnesty International USA, and Judge Wood is going to tell us a little bit about that case.
All right, this is a case, in some sense, that really arises out of the many efforts of the government in the post-9/11 world to, I'll use the word improve foreign intelligence collection. I think a lot of people thought that prevention was a lot better than after-the-fact actions in that atmosphere. And so a new statute was passed in 2008, adding to the Foreign Intelligence Surveillance Act additional powers for the government to conduct electronic surveillance. And it's an interesting statute, and it emphasizes the idea of targeting non-United States persons outside the United States for the purpose of collecting foreign intelligence. And you might think initially, well, you know, okay, so it's the CIA over there in some other country, and they're targeting a non-U.S. person, and it's not happening in the United States. That really sounds like something that might not trigger all of the same protections that we expect as United States citizens. But the plaintiffs in this case, who are a set of lawyers, journalists, human rights organizations, the lead plaintiff, Amnesty International, say that these procedures, in fact, violate the Fourth Amendment, the First Amendment, Article 3, because, in a sense, they're just a bunch of general warrants. They allow the executive branch sweeping, they say, and virtually unregulated authority to monitor the international communications of U.S. citizens and residents. And the reason for that is that packed into this word targeting is the fact that there's an awful lot of other information that gets collected if you're focusing on this non-U.S. person. And the plaintiffs are concerned in this case, and they actually sued immediately upon the effective date of this law to enjoin the law because they said, we are going to be swept up in this operation. So the district court in this case, Judge Katyal, granted summary judgment for the government. Judge Katyal found that the plaintiffs lacked standing to sue. And then the case went to the Second Circuit, and an opinion by Jerry Lynch, that decision was overturned. And Judge Lynch's opinion emphasizes that the only question before the Court of Appeals, before the court at that point, was the standing question. And he writes an opinion upholding the plaintiffs' standing. It then is subject to a petition for rehearing before the Second Circuit, in which that court splits 6-6. And of course, you can't get rehearing and bank unless you have a majority of judges to rehear. And 6-6, as I well know from many of our 5-5 decisions in the Seventh Circuit, isn't a majority, it's a tie. But there are some very interesting opinions, primarily the opinion written by Judge Rina Raji, arguing that Judge Lynch's opinion was sorely mistaken, and these plaintiffs had only highly speculative injuries, and so on. And from that, the Supreme Court grants cert. So we have, you know, you've seen this before. We have a situation where the technical issue before the court is a standing issue, but lurking immediately behind that curtain of standing are some extraordinarily sensitive foreign policy issues, foreign intelligence issues, really even, I would say, military issues, however you want to put it. And so let me just review a little bit of what the Second Circuit said. The first thing they said was that the plaintiffs, and I'm speaking of Judge Lynch's opinion right now, that the plaintiffs had in fact definitely met the injury in fact requirement for standing, because their allegations show that right now they are spending a fair amount of money to try to avoid the kind of surveillance that this statute permits. Basically, I should double back and say, the government doesn't need to do too much before the Foreign Intelligence Court to obtain a mass surveillance authorization. They just have to submit a written certification and some signed affidavits. The affidavits have to say, according to the statute, that, quote, a significant purpose of the acquisition is to obtain foreign intelligence information. They have to attest that they have adequately targeted. They have to attest that they have adopted minimization procedures to make sure they're not picking up too much that's not within the focus of the statute. And the targeting procedures are those that are designed to prevent the intentional acquisition, notice the word intentional, of any communication as to which the sender and all intended recipients are known at the time of the acquisition to be located in the United States. And there are a bunch of other aspects to the certification procedure. But if the court reviews all of this, it has to issue an order authorizing the government to conduct that surveillance. And it can go on for a year. The government can appeal the denial of a certification to the FISA Court of Review, but it can continue to collect intelligence while the appeal is pending. So anyway, against this backdrop, the plaintiffs said that, for example, if they were trying to communicate with their clients, they made some fairly specific allegations. Footnote 11 of Judge Lynch's opinion sets some of them out. They note that attorney Scott McKay communicates with his client Samir Omar Al-Hussein, somebody else's client he helps represent, Khalid Sheikh Mohammed, a name probably known to you, being held at Guantanamo, family members. So there are allegations in the complaint, and what the plaintiffs say is, in order to avoid this surveillance, we actually can't use telephone calls, we can't use emails, we actually have to fly physically to the place where our clients are so that we can have a conversation. This is burdensome, this is expensive. And so this is both a current cost and as well as a risk of future surveillance. So Judge Lynch finds, okay, injury in fact is fine, and he's willing to find, based on the information included in the complaint, that the injury is caused by this law and that it's redressable. One could simply say that the Fourth Amendment really does apply and issue an injunction, and you could find redressability. The dissenters, led by Judge Raggi, and now the government in the case before the Supreme Court, violently disputes that. They believe that this is really totally conjectural, that the plaintiffs haven't put enough information into the complaint. So since I'm rather short on time, what I will just say is it's hard to imagine, given the structure of this law, putting much more information than they put in. So if this is legally insufficient for standing, my own view is that it's actually a way of saying that this is a non-justiciable question in a much broader sense. It's hard for me to imagine, given the secrecy of the whole process, plaintiffs coming up with more information than this. But on the other hand, if we think that it really is sufficiently outside the scope of United States authority, and we're going to, and Congress is empowered to allow the foreign intelligence agencies to conduct this kind of thing, it feels a lot to me like a merits decision, or at least a non-justiciability decision for separation of powers concerned.
Neal
I guess I'd make 2 points. One is just the statute is pretty, has a bunch of restrictions on what the government can do, and it's important to keep those in mind as you think about the case. It says that an acquisition authorized may not intentionally target any person known at the time of the acquisition to be located in the U.S., that you can't target someone abroad the U.S. if you think that the purpose is to just capture the conversation of someone else who's in the United States. It says you can't target a United States person if they are believed to be abroad, and that everything has to be done in a manner consistent with the Fourth Amendment. So there are a bunch of restrictions laced into the statute. The other point I think about is just kind of situating this case in the context of these blockbuster Supreme Court terms. Justice Brandeis once said that the most important thing the court does is not doing. And here, that led, for example, Alexander Bickel to write his thesis about the passive virtues, that the virtue of the court, or the power of the court comes from not doing too much. And you might ask, well, they've had the Affordable Care Act, they've had Arizona, they're about to have affirmative action, and a whole bunch of decisions. Boy, they're really doing a lot right now. And the national security area is a place that the Bickel thesis has traditionally had a lot of currency. The court doesn't like to get too involved in the national security area. They think of themselves as generalists, not military specialists and the like. And here they are again, taking another case, big blockbuster case potentially, about surveillance. With respect to that, at least I think this isn't a good example of that, because here you've had already the Second Circuit come in and say this claim can proceed, and we can have litigation about that. And so the Supreme Court, I think, almost has to get into this. It is a pretty extravagant view of standing, in my view, that would allow that anyone who has a fear of something and then spends some money as a result of that fear, to those two things together, to cobble together to create standing, that's a tough one. And so I think the court almost had to take this case. But they continue, for the last several years in the national security realm, not to take too much. They've kept on denying Gitmo case after Gitmo case for years.
Yeah, I mean, you can describe that as an extravagant view of standing. I'm not sure it's exactly the one that Judge Lynch had. You can also say an extravagant view of standing is that no one can challenge, the application of the statute, which is the practical consequence of the opposite rule, unless there's an inadvertent disclosure. And so, it depends on how you characterize the different rules. The thing I will say is that in the body of cases that the court is deciding this term, standing and mootness, who has the ability to sue and when a case is over, is a theme that runs through fully a fifth of the docket. It's kind of, the court has taken a bunch of cases like this, and I think that'll be one thing that you see running through a lot of the court's decisions this term.
And let me just circle back and say one thing, which is that I see in this case also threads of the court's concern about how specifically people need to allege things, which has come up in Twombly, it came up in Iqbal, it came up in a lot of cases, and it's hard for me to imagine plaintiffs describing more than they have described. They just don't have the information. So that's why I say, in a sense, if the court just wanted to say, look, this is just a non-justiciable area. This is national security. We are not the branch of government that are supposed to be involved with this. In my view, that's really less of a standing complaint than it is really just an entire subject matter complaint.
Do you have questions from the audience?
If the standing is established here, the government still has the option of shutting down the entire litigation by pleading executive privilege. Why have they not done so up to this point?
Neal probably has
I'm not talking about that. Yeah, I can't talk about that. But in general, state secrets is something that this administration's been kind of careful not to invoke unless they absolutely have to.
Well, also as a last resort versus first resort, I mean, you would expect them to try and resolve this question first. Whether they might do so in the end, I suppose, is not yet a resolved question. Right?
The government's assertion of state secret privilege has shut down at least 5 cases in the Supreme Court in the last 10 years. So to talk about this as being a modest assertion is, to engage in.
Well, all I was talking about is with this administration, I think has been extremely careful to invoke state secrets. I do see Beth Frankman in the back, so you can direct all questions that way.
Let's take another question.
Yeah, this is for Judge Wood. I'm struggling on the FISA, the Clapper case. In ordinary criminal investigation, when the FBI gets a warrant to wiretap somebody, and I, as a perfectly innocent person, happen to talk to that person on the telephone, I'm picked up. Despite that, I am never my name is never specified anymore, and there is minimization of some kind. different with the FISA warrant? I know it's a basket warrant, but it's not, the warrant for the foreign target is a general warrant that lasts for a year and so on, and it's not a specific warrant. But the sort of collateral damage situation seems to be exactly the same.
Well, in some ways it is the same, although under Title III there is minimization, which is required. Now I know the word is in there, but I think what the plaintiffs are saying is that given the nature of the FISA procedures, they don't even know when the warrants, I mean, they have so little opportunity to challenge the scope of the warrant that it is in fact different from the domestic situation. I will say though that one thing I probably should have mentioned is one of the points made by the dissenters, the Second Circuit, made in the government's brief, is that even if this whole avenue were shut down by this litigation or some other way, there are quite a few other avenues available to the government. I think it's another reason why they think that this litigation is just not something that should go forward.
And on the other side, one other piece that on the plaintiffs, they did put in an affidavit by Stephen Gillards, who's a famous NYU legal ethicist, that said that in his opinion, it would that because of the fear of surveillance that these attorneys have, that it would be almost a violation of legal ethics for them not to proceed thinking that they're not being surveilled.
Okay, we're going to have to move on to the next cases. Tom Goldstein is going to tell us about China versus the United States and Moncrief versus Goldstein.
These are two criminal immigration cases. I should disclose that we're counsel in both of them. Jeff Fisher is doing the important case, which is China's case. I'm doing the unimportant case, which is Moncrief. China's case presents the very important question of whether the Supreme Court's decision in Padilla versus Kentucky, which held that you have a right to have your criminal defense lawyer tell you about the immigration consequences of the criminal proceedings, in particular a plea agreement, that is a Sixth Amendment right, that if you were going to plead guilty to an offense, you have the right to know whether that will make you deportable, for example. The Supreme Court had held that very recently. What the question in China is, does that decision apply retroactively? Does it apply to cases that became final before the Supreme Court decided the Padilla case? And it comes up in the context of where someone went through a proceeding and is now on, it was a federal criminal proceeding, and they're now on federal habeas. And the Supreme Court is going to decide whether other cases that predate Padilla are subject to the Padilla rule, so that the non-citizens in those cases can invoke the Padilla decision to collaterally attack or attack on appeal their guilty pleas. And it is a fight about the scope of retroactivity law under basic principles of federal habeas corpus. The position of Chaidez that Jeff Fisher is arguing is that when the Supreme Court decided Padilla, it was just applying its very long settled rule in the famous Strickland case about the basic things that lawyers have to tell their clients. And this was an ordinary rule, ordinary application of that rule, just to a distinct circumstance. And the Supreme Court consistently has held that applications of the Strickland standard do apply retroactively. The government says, no, this is not an ordinary application of Strickland. It is a new rule, which would make it non-retroactive because no one thought this was the rule. 10 courts of appeals and 28 out of 30 state Supreme Courts had ruled that this immigration advice is not part of your Sixth Amendment right to counsel, so this is a very unusual new rule the Supreme Court announced in that Padilla case, and it shouldn't apply retroactively. Another, for folks involved in habeas corpus, another issue in the case is, does the retroactivity standard that the Supreme Court announced in a famous case called Teague apply to a federal habeas challenge to a federal conviction or not? And so there may be a difference in how Padilla applies in federal convictions versus state convictions. But for the immigration community, this is a very significant thing because lots of people get terrible immigration advice, which is what led the Supreme Court of the Padilla case in the first instance to say that, yes, you have to tell your client about the immigration consequences of their plea agreement. And there is a material body of folks who got bad advice, who are caught in the space, where their cases are still pending in collateral review after the Padilla decision. The second case is the Moncrief case. This is about the immigration consequences of a conviction for distribution of marijuana or possession with intent to distribute marijuana. The question is such a conviction one that is automatically deportable? That is it an aggravated felony under the federal immigration laws, or instead is it one where the Attorney General gets to decide if the person will be removed? Is it a so-called controlled substances offense? The situation here is that Moncrief is arrested in Georgia, driving through the state with 1.3 grams of marijuana, which is about half the weight of a penny in marijuana, and pleads guilty to possession with intent to distribute marijuana. He had someone else in the car with him. 3 years later, the federal government, he's from Jamaica, all of his family's here, 3 years later, the federal government picks him up and says, you've committed the aggravated felony of illicit trafficking in marijuana. And the reason they are able to say that is that the structure of the federal drug laws is such that if you don't, your conviction itself does not establish the amount of drugs, then it is presumed that you had up to 50 kilograms of marijuana. Now, he had 1.3 grams, which is less than 50 kilograms, it turns out. But when you, I went to the law to avoid math, but this I'm fairly confident about. But the thing is that the Georgia state conviction, he just pleaded guilty to possessing with intent to distribute marijuana. And it doesn't draw any distinctions on based on the amount of quantity. And because the conviction itself doesn't say how much he had in terms of drugs, the federal government says, well, then he's treated as having less than 50 kilograms, and that's a felony. Whereas there's another provision of the federal drug laws that says if you possess with intent to distribute a small amount for no remuneration, that's a misdemeanor. But they say that his conviction doesn't show that it was a small amount for no remuneration. They have, in their merits brief, they have said, well, we'll let him attempt to prove it in a second proceeding. But that's the fight. So it's going to be the treatment of marijuana convictions for federal immigration purposes. There are a number of people who are convicted on this basis. There was a circuit split about it.
Thank you. So I believe China's is from the 7th Circuit, and Judge Wood may prefer not to weigh in on that, but would either of you like to weigh in on either of these two cases?
Well, all I'll say about China's is that the majority of the 7th Circuit ruled that it was a new rule and thus unavailable, and I was among those who voted unsuccessfully to rehear it. So as to Moncrief, though, I mean, the interesting thing about that is behind the surface in Moncrief is this whole construct that the Supreme Court has built about how you handle prior convictions. Do you just have to look at the face of the indictment? Do you have to look at the face of the judgment? Can you peel behind and look at all of the facts, some of the facts? And for purposes of the Armed Career Criminal Act and for purposes of the sentencing guidelines, they use what they call a categorical or a modified categorical approach. And so there are only certain things that you can look at. You have to figure out if it's a divisible offense and so forth. And that approach has been used in the immigration laws. Another option, and the court has actually said that the Board of Immigration Appeals is entitled to do this, would just be to say, let's just look at the whole thing, including the fact that this happened to be 1.3 grams. They haven't wanted that in the criminal area because of a real concern about mini trials all over again and finality and other things. Whether that rule should carry over to immigration could conceivably come up, I think.
I don't know if I just want to know what is your proposed rule to deal with this?
Our proposed rule is to say that because it could be either a federal felony or a federal misdemeanor, you treat it as the misdemeanor under this categorical rule. That is, the conviction does not establish the felony. And we say, what is the big deal here? All our position is that he's not automatically deportable. If you decide that the non-citizen is a serious enough offender to remove them, then the Attorney General has the discretion to do that. The only upshot of our rule is not that the non-citizen gets to stay in the United States, but that it's the Attorney General's discretion. We say it's kind of odd that Congress would insist that someone who had such a small amount of marijuana is an aggravated felon who has to be removed from the United States.
But the Attorney General would have to be a discretionary judgment. The AG couldn't make a categorical discretionary judgment that says on his own, I'm going to, in any amount of drug conviction, automatically.
No, and that's clearly would be unlawful because the structure of the statute is that if it was a misdemeanor drug offense, then the person is it's within the Attorney General's discretion, and so it would, I think, be very odd for the Attorney General to say, by Congress giving me discretion, that Congress intended me to remove all of these folks.
Are there questions from the audience on either of these cases? Yes.
I was just curious, in the Padilla case, the question of retroactivity came up. If, an oral argument or in the briefing, if it's something that we can read the tea leaves about.
Well, in all of these cases where the court is asked to announce a significant rule of criminal procedure, lurking in the background is the concern of how much it will open up the floodgates. And so there's no question but that the majority knew that the next case would be the retroactivity one. And the government in cases like this will always flag the concern of this isn't just going to be a forward-looking thing. There's people are going to come and try and open up a lot of prior convictions. But it remains the case that the court has the option of denying retroactivity. Of course, our position is that this is, every single time that the court has had a post-Strickland application, it is said it's not a new rule, but we will see.
All right, so we're going to finish up with some thoughts on the detainees. And I'm going to talk about a case called Garcia versus Thomas, which is hanging around the Ninth Circuit and may find its way up to the Supreme Court, although given their current proclivities on detainee cases, probably not. Just for some background, habeas corpus was originally designed to allow people who were detained to challenge that detention, detained by the executive branch to challenge it. And recently, some of the issues that have come up are, do federal courts have this habeas corpus jurisdiction to look into the detention by the executive? And in 2008, in an opinion by Justice Kennedy called Boumediene versus Bush, the court said, yes, we do have jurisdiction to look into detainee cases, at least at Guantanamo Bay, maybe broader. And in language that only Justice Kennedy could use, he said that our political branches cannot switch the Constitution on and off by taking people out of the United States and putting them elsewhere. We, the courts, can still look at that. So there seems to be a presumption in favor of federal jurisdiction. That's all well and good. But if you're the detainee, you have this question. Well, what does federal habeas review actually get me? The Supreme Court has told us virtually nothing about the answer to that question. But the courts of appeals so far have found that the answer is not very much. So you get federal habeas jurisdiction, but you don't get much in the way of review. And one of the underlying substantive issues is raised by Garcia versus Thomas. Now, this case comes in a somewhat unusual procedural posture because it's an extradition case, and may for that reason differ from some of the other cases. But basically, Garcia is saying, I do not want to be extradited to the Philippines for crimes because I fear that I will be tortured there. And the United States government has a policy that we do not transfer to countries where there's a substantial likelihood that someone will be tortured, where it is more likely than not that they will be tortured. So Garcia says, hey, district court, I have a federal habeas petition. You should be able to review whether or not I'm likely to be tortured in the Philippines. Well, the Ninth Circuit said, we can't do that. And they relied on a case by the U.S. Supreme Court called Munaf versus Jaron, which was decided the same day as Boumediene and has gotten very little attention. That case involved 2 United States citizens who filed a petition for habeas corpus. They were held by the U.S. military, and the Iraqi government wanted to get them back into the Iraqi courts for crimes there. Keep in mind, 2 U.S. citizens. The U.S. Supreme Court said, well, we have jurisdiction to decide whether or not these U.S. citizens can be transferred. But we don't really have the power to second-guess the Secretary of State's decision that the Iraqi courts are fine for our U.S. citizens. The Secretary of State thinks they're fine, they'll treat us fine, they'll treat the U.S. citizens fine. We're not going to second-guess that decision. The Ninth Circuit and the D.C. Circuit have taken this decision and said, we can't review what might happen to a detainee if they're transferred elsewhere. So the majority of the Ninth Circuit in the case below said, we can't do very much at all, other than require Secretary of State Clinton to file a paper with the district court that says, we believe it is more likely than not that Garcia will not be tortured if he is sent to the Philippines. Two judges on the Ninth Circuit said, no, we can actually look at the underlying substantive decision, whether it actually is more likely than not that he will be tortured. The majority said no, and the DC Circuit has said we had even less review over this. So why might we trust the government? Well, the government has typically more information, more expertise on what is going on in a foreign country, far more information than the federal courts. And that's one of the reasons federal courts tend to defer to the government on this. But why might we not trust the executive branch? Well, if you're the State Department and you're trying to have good relations with the Philippines, it does not look too good if you say, well, you guys are great, except for the fact that you torture people. So there's a bit of a political pressure on the State Department not to find that there is torture committed in other countries. It doesn't mean what the State Department finds is wrong, but it means that we might start to question it. But as it stands, the Courts of Appeals are saying there's not much that we can review there. Thoughts on that, or on some of the detainee issues involving Guantanamo Bay?
Let me just, to put it in a little bit broader perspective, the Convention Against Torture was implemented in U.S. legislation, and it is absolutely routinely raised in asylum applications. Anybody who's asking for asylum is automatically also understood to be asking for cancellation of removal, and they're also automatically seen to be asking for relief under the Convention Against Torture. So the immigration judges and the Board of Immigration Appeals in the non-extradition area look at these cases all the time, and the Courts of Appeals on petitions for review from the BIA decisions look at Convention Against Torture cases all the time. So, you know, and it's an administrative review, of course. There's deference to the fact findings that are made by the agencies and so on. So it's a little counterintuitive for a court like the Ninth Circuit that sees legions of these cases to be told, well, in this case, you have to put blinders on because you can't look at whether torture is likely. On the other hand, of course, extradition is under its own legal regime. There has to be a treaty. You know, there are arrangements made between the two countries when somebody's going to be extradited. So I just wanted to say that don't think that this is an isolated issue, because it really isn't. It fits into a much bigger context.
And the real question in these cases is, in a removal context, people can say, please don't remove me to a particular country because I might be tortured, as a defensive matter. In the habeas context, it's more as an offensive matter. Can I affirmatively assert the torture convention to control, have the courts control what the executive is doing?
I think it's helpful to think about this case in connection with the Gitmo cases. You know, as I was saying a moment ago, with respect to Guantanamo, the court heard 3 cases between 2004 and 2008. In 2008, both presidential candidates said Gitmo should be closed. So did most of the Bush administration senior officials. And it looked like that was where things were going to go. That's clearly not happened at this point. There's still roughly 160 people at Guantanamo. The Court of Appeals has decided case after case against the Guantanamo detainees. And all of those folks file cert petitions, and the court keeps saying, keeps denying them. And at first it was thought that these were being denied because Justice Kagan was involved with many of them when she was Solicitor General. But in the latest batch, she sat in the sense that there was no recusal noted, but there were still denials. And I do think that that reflects a kind of the traditional court's views about passive virtues, about not getting involved in national security cases in 2004 to 2008 being more of an aberration. One can ask why. Maybe something had to do with, I think, the way in which the court viewed the executive branch at the time and the kind of claims that were being made, and the feeling that they had to get involved, whereas I think they don't feel as much of that impulse at this particular moment, whether rightly or wrongly. Now, I don't know that that carries over to this case, though, because I think you know, this case doesn't raise in really the same stark ways the national security implications. And this is an area that, I mean, for 15 years or so, there's been just so much robust disagreement and talk about in the lower courts about cap claims and so on, that I do think I wouldn't be surprised if the court takes this one. This is one in which what happened, the Supreme Court stayed the mandate or something last month, and then the cert petition is coming in mid-October. So.
Yeah, I will confess my surprise that the U.S. Supreme Court has stayed out of the last 3 generations of detainee litigation in the D.C. Circuit. Because once the Supreme Court established jurisdiction, as Tara said, then it has never said more really about what the federal courts are supposed to do with these cases. And in general, in important areas, the Supreme Court likes to have the final word, but they've been offered that opportunity 15 times and have just said this is going to be the D.C. Circuit's to decide, and that just surprised me. That's unlike them. And there have been some pretty aggressive attacks by some of the judges of the D.C. Circuit on the Supreme Court's jurisprudence that generally succeeds in getting the courts back up and interesting them in an area, but not so here.
Do you have questions from the audience on these issues? Yes.
Just to follow up on what Tom just said, there was a language by Judge Brown, it was the Lotke case, Lotke, that, is that the law now? That she talked about the airy, I forget the very nasty language. Airy suppositions. But that was a very indulgent standard about the government's evidence. That's debate that the court doesn't want to take, and why not?
It's a great question, right? The D.C. Circuit has taken a lot of life out of Boudin. For those who agree with Boudin, that would seem problematic. And not just Judge Brown, but I think Judge Randolph has made quite a few statements directly critical of the Supreme Court's decision.
I was going to say, and that's not just on the more conservative side of the D.C. Circuit. This is Judge Tatel in his dissent in Lateef, quote, "It is hard to see what is left of the Supreme Court's command in Boumediene." So, I mean, it's kind of, yes, a real kind of gutting of the decision, and the question is whether or not the court will feel compelled at some point to get in, given all of the kind of recent D.C. Circuit opinions.
Lyle?
Just to bring this back around, the source of the D.C. Circuit's ultimate jurisprudence against the Guantanamo detainees is the Munaf decision itself, because as interpreted in an opinion by Judge Randolph in one of the Chinese Uyghur cases, he read Munaf in the most expansive way possible, and as a consequence, I think the reality is, the jurisprudential reality, is that Munaf has totally swallowed Boumediene, and Judge Tatel, I think, is not just making an argument. I think he is stating the fact that if you are a Guantanamo detainee, or now, and this is developing at Bagram in Afghanistan, if you are a U.S. detainee in Bagram, you have almost no possibility of getting, not only not getting much of a hearing, but absolutely no possibility of getting any relief, and that's due entirely to the county.
And I will say for all the students in the room who find these issues interesting, we will cover them in federal courts next spring. So take the course. And thank you very much.